We will now discuss on our last topic for labor relations, which is strikes and lockouts and foreign involvement in trade union activities. This also includes special provisions on labor relations. And this is the part one of this series of lectures on strikes and lockouts. As we come to understand the nature of an employer-employee relationship, they have conflicting interests. And so this could be a basis for conflicts, which we call industrial disputes. And this is the way to understand employer-employee relationship. And so we have come to understand that within the employer-employee relationship, it is unavoidable that we would have conflicts or industrial disputes. And because employer-employee relationship is also imbued with public interest, their relationship and even labor disputes could be the basis for the government to intervene. And as we have said, the employer-employee relationship is imbued with public interest. It's because in industrial disputes or any conflict arising from an employer-employee relationship would cause inconvenience to the public because it would disrupt production. It would damage the local or national economy if there is disruption of production and even if there is disruption of the market. And it is likewise a threat to public health and safety and injury to the defense program. And it could also give bad reputation to the country. Just remember during the times na puro welga ng bayan or there are transport strike, this would all create disruption within the economy and it gives a bad image to the country. And overall, it has an impact to the overall economy of the country, and it has an impact on the overall lives of the people. Concerted activity, you take note of the definition, is a joint undertaking of workers designed to secure better terms and conditions of employment through the machinery of collective bargaining and negotiations for their mutual benefit and protection. Ito yung imbes na yung empleyado isa lang siyang haharap sa employer, as we have learned previously, na he would not have the same power if he were in a group, like a labor organization, that they could collectively present their sentiments or present their demands. And so that is the very objective of employees having to collectively organize themselves and to have concerted activity for the presentation of their demands against the capitalist or against their employer. Strike, we are familiar with strike, napapanood natin ito sa TV, but you take note of the definition. It's a temporary stoppage of work by the concerted action of employees as a result of any industrial or labor dispute. It could be yung nakikita nyo strike sa TV, yung merong hawak-hawak na placard, tapos they demand change from the government. That is a form of strike, no? But there could be other forms of strike. It could be just within the bargaining unit where the labor organization or the employees would make certain demands, for example, better working conditions. And so they could initiate certain activities collectively that would sabotage or that would bring about attention, no, for attention for them to voice out their demands. So that is strike. To constitute a strike, there must be stoppage of work, and it must be temporary, and it must be the result of an industrial dispute. Mass resignation is not a strike, because in a mass resignation, the purpose is for the termination of employment. In a strike, the purpose is not for the termination of employment, but merely a temporary stoppage of work for the employees to voice out their demands. The purpose of a strike is to put economic pressure upon the employer, because if the employees collectively tigil sila sa production, then it would have an economic impact upon the business of the employer. And not only an economic impact, it would also have an impact on its reputation as a business. And so as much as possible, the employer would want to avoid this situation that its employees would stage a strike, because any interruption or stoppage of production, it means loss to the employer. We have kinds of strike. We have authorized strike. These are called upon and approved by the majority of the members of the union. We also have the unauthorized, yung biglaan na lang na nag-call upon ng strike. And this is a strike that did not go through the process of approval, or did not go through the process of recognition to be an authorized strike. General strike, no, it has wide coverage. It is most extensive. Usually you see them tuwing May 1. Ito yung mga welga ng bayan, or you have yung, if it pertains sa mga transportation group, we have yung transportation strike, mga ganon. Or we have labor unions or labor groups staging strikes all over the nation simultaneously, then that is a general strike. Then we have the particular strike. It is limited in scope. It could be, it covers only a particular plant or a single occupation or trade. Usually naman, for example, yung sa mga jeepney drivers, when it affects jeepney drivers, yung strike na yon. Or it could be in a particular organization like the employees of Nestle Philippines, for example, or the employees of the Lushotan Group, uh, all the businesses under the Lushotan Group of companies, for example, or that is a particular kind of strike. We have a quickie, no? Ito yung mabilisan lang. It is characterized by an impromptu brief work stoppage in plant. Few minutes lang, mga 30 minutes, tigil trabaho lang siya. And that is to voice out the demands of the purpose is to voice out the demands of the employees. That is a quickie strike. We have the slowdown, which is another form of a quickie strike, no, is an activity by which the workers, without complete stoppage of work, they retard production of their performance of duties. Ano lang sila, they invest na, for example, the quota daily is 100,000 units in a day. What happens is that yung mga employees, ang magiging output lang nila would be 50% of the quota or of the plant capacity. That is slow down. Sit down, it is similar to quickie, no? Ang gagawin lang ng mga tao ay they would just paupo-upo lang. The workers remain in the plant. They expect to be paid, but they refuse to work, and their machines and tools remain idle. No, they would just be in their workplace, kaya lang hindi sila magtatrabaho. That is a sit-down strike. And again, the purpose, of course, is to retard the production, which would have an adverse effect on the business of the employer. Ordinary strike, it is the common type of strike that involves withdrawal on the part of the workers from their place of employment. Ito yung usually gagawa sila ng mga activities. Lalabas sila sa kanilang workplace, doon sila sa harapan ng place of work nila, and they would stage strike. Meron silang mga placard or pwede silang mag-set up ng mga tent doon, no? In order to voice out their demands. Sympathetic strike, this is carried on by workers in sympathy to another group. So it could be na yung isang planta ng within the business group, halimbawa, you have yung sa Nestle Philippines in Cabuyao, one plant, sila yung sa dairy production, another plant, sila yung sa beverages, no? So if yung sa plant for beverages ay nag-strike, then yung another plant nung sa dairy, if they join the strike, they are called sympathetic strikers. And then yung legal naman, legal strike, it is for legal means, and yung purpose niya is legal and the means used are also legal. These are authorized strike. Illegal, these are prohibited strikes, no? When there is already an injunction for them, or when the strike is declared to be illegal, then that is an illegal strike. We have a strike for unfair labor practice. is a strike states as a result of employers or unions' unfair labor practice. It arises out of violation of the right of workers to self-organization. We have learned about unfair labor practice already, and so it pertains to, if the strike pertains to unfair labor practice, then that strike is called an unfair labor practice strike. Economic strike is, the purpose is to have economic concessions, to demand for economic concessions from the employer. And it involves issues pertaining to demand for higher wages, higher pension, or overtime rates, pensions, profit sharing, shorter working hours, yung mga ganun, better health services, better sanitation, yung mga ganun. And then we have yung temporary or concise stoppage of work. This is an unlawful concerted activity which usually takes place in case there are unscheduled union meetings, which in the process, yung mga union members were compelled to withdraw, no? Dahil sa meetings, union meetings, union members would not be able to work. They become unproductive. And so, in essence, that would also be considered a strike in, if it is intended to make them unproductive and intended to make an economic sabotage of the production, which would have an adverse effect on the business of the employer. We have the union recognition strike, which the purpose of which is to compel the employer to recognize one's union as the employee's bargaining agent. Remember what we have discussed before, in order that a labor organization or a labor union would be recognized as the SEBA, or the sole and exclusive bargaining agent, it has to be recognized in a certification election, or in a runoff election, or in a rerun election. And so if the strike is intended for a recognition as a bargaining agent for purposes of CBA, and not through a certification election or for any other means, legal means for recognition as SEBA, then that strike is called a union recognition strike. We have a lightning strike. This is a sudden stoppage of work by the concerted action of workers without compliance with the requirements. This is, kung minsan, ito rin yung wildcat, parang equivalent ng wildcat, no? Pag lightning strike, mabilisan lang, tigil trabaho. This activity is illegal. A strike or lockout may be declared in cases of bargaining deadlocks. Ibig sabihin, in case there are deadlocks during negotiations of a CBA, and in cases of unfair labor practice. There are instances when no strike or lockout may be declared. First, in case of violation of CBA, collective bargaining agreement, except flagrant and malicious refusal to comply with economic provisions, which would be tantamount to unfair labor practice. But otherwise, if it is just a mere violation of the terms and conditions in the implementation of the terms and conditions of CBA, then that is not a ground to declare a strike. In case of inter-union or intra-union disputes, then it's not a basis for declaring strike or lockout. We have learned before about inter-union disputes and intra-union disputes. Inter-union is a matter of a representation issue, the recognition between two union as to who among them would be declared in as the sole and exclusive bargaining agent within a bargaining unit. Intra-union is these are issues or disputes with respect to membership and with respect to issues within a union, uh, like election of union officers. And also when the necessary requirements for a declaration of strike are not complied with, like having to file a notice to strike first or lockout, or without the necessary strike or lockout vote having obtained and reported to the NCMP. Also, when there is already an assumption of jurisdiction by the Secretary of Labor and Employment, remember that there are indispensable industries in which the Secretary of Labor and Employment would assume jurisdiction anytime. It's because they are important industries that would have an impact on for national interest purposes. Any certified, duly recognized bargaining representative may declare a strike. And also, with respect on the part of the employer, they could declare a lockout. The discussion on lockout would be on the second part of this lecture. The requirements for a valid strike or lockout: it must be based on a valid and factual ground. It must be approved by a majority of the total membership of the union by a secret ballot in a meeting called for the purpose if it is a strike, or in case of a lockout, then by the majority of the members of the board of directors of the corporation or association or partners in a partnership. And a strike or lockout notice shall be filed with NCMB or the National Conciliation Mediation Board at least 15 days from intended date if the issues raised are unfair labor practice, and at least 30 days if the issues raised involve bargaining deadlock. The failure of the union to serve a copy of the notice of strike to the company is a violation of due process. And then compliance with the 24 hours prior notice rule and on strike voting. So in case there is a strike vote, then the employees in the bargaining unit who are qualified to vote must be given sufficient time of notice for them to vote. And also, the result of the strike or lockout vote has to be reported to the NCMB Dole regional branch at least 7 days before the intended strike or lockout, subject to the cooling off period. The purpose of yung 15 days, 30 days, and even tong 7 days, no, is to give the government, especially the NCMB and the DOLE, to intervene and to facilitate mediation and conciliation para it would not whatever labor dispute would not escalate into a strike, because a strike should be the last resort, the last remedy, because the strike would give yung maximum damage to labor relations, to any labor relations, no, and even sa production, and even to the business. In case of union busting, ibig sabihin yung the union is being disintegrated, no? It is an effort ng employer to terminate or to disintegrate yung union. The requirement for the filing of the notice of strike shall be dispensed with, but the strike vote is mandatory. No, it has to be complied with. Ibig sabihin, pag in case na merong union busting, merong harassment sa mga officers, sa mga empleyado for the purpose na mapawala yung labor organization, the filing of notice of strike, pwedeng agad-agad, kaya lang yung strike vote has to be complied with still. Strike vote is designed to ensure the overwhelming sentiment that the decision to strike broadly rests with the majority of the union members in general and not with a mere minority. That is to ensure na the decision to strike has the mandate of the majority of the union and not a mere decision of the minority. At the same time, it will discourage yung wildcat strikes, yung mabilisan and unauthorized union busism and even corruption, na yung magdidictate na lang ng about the union would be yung mga officers o yung minority, o yung magdidikta hinggil sa pamamalakad sa business would be yung union na, no longer the employers. The 15 and 30 days requirement, which is known as the calling off period, again, pag 15 days, in case there is unfair labor practice, 30 days in case of CBA deadlock. No? It is designed for the NCMB to give an opportunity to the parties to make an amicable resolution of their dispute, no? That is to avoid na mag-escalate siya into a strike or mag-escalate into a lockout. The purpose of notice is to provide an opportunity for mediation and conciliation. We have discussed this a while ago. The requirements for valid strike or lockout are mandatory in character. Non-compliance of this would make the strike or lockout illegal. If a strike is illegal, this is a consequence, no? The employer may be authorized to terminate the employment of union officials who knowingly participated in the illegal strike, or any worker or union officer who knowingly participated in the commission of other illegal acts during the strike. So, pagdating sa union officials, their participation knowingly could be a basis for their termination of employment. Pero pagdating sa mga workers or sa mga members, they must have knowingly participated in illegal activities to be terminated. Hindi po pwede na terminated lahat na yung buong members ng union. there is a differentiation with respect to the participation of union officials and the workers pertaining to the right of the employer to terminate them in case of illegal strike. In case the lockout is declared illegal, remember yung lockout is an initiative of the employer. Pag lockout, ibig sabihin ay hindi magpapapasok yung employer sa mga empleyado. Any worker whose employment has been terminated as a consequence thereof may be entitled to reinstatement, including payment of full back wages and other benefits. If in case the employer decided to declare a lockout, ayaw papasukin yung mga empleyado because of a labor dispute, no? And it is declared illegal, the lockout is declared illegal, those whose employment has been terminated, they could be entitled to reinstatement, including payment of full back wages and other benefits. It would be tantamount to illegal dismissal. Even if the strike were to be declared valid because the objective and purpose is lawful, it could still be declared invalid if yung means niya, yung pamamaraan niya are illegal. Like the use of guns or the use of goons, yung mga ganon. And so, for a strike or a lockout will have to be declared lawful, the means and the purposes, yung purpose niya as well as yung pamaraan niya should be both lawful. And so that ends our lecture on strikes and lockouts for part 1.